Imagine waking up one day in a world where your future, your fortune, and even your very voice could be stripped away simply because of who you were born to be. Imagine a time when your dreams of inheriting a sprawling estate, ruling a powerful kingdom, or even just picking your own partner were practically impossible. What if the most basic freedoms you take for granted today were not even a whisper in the wind, a forgotten notion in the dust of history? Welcome to the world of 600, and where for women, life under something called Salic Law was a maze of limitations and stark realities. Number 1. The right to control personal property after marriage. Imagine for a moment you are a young woman, perhaps named Theodolina, in the year 600, living within the sprawling, sometimes chaotic lands of the Frankish kingdom. You might have been born into a family of modest means, perhaps a farmer's daughter, or maybe even to a more prosperous household, a landholder's kin. You might have had a few personal trinkets, a finely woven cloak, a silver brooch gifted by your grandmother, or perhaps a small plot of land your mother passed down from her family. These were your things, your personal possessions, and in a world where few people owned much, they represented a connection to your heritage and a small measure of your own identity. But then, as the custom and law of the land dictated, the time came for you to marry. Marriage in 600 AD was rarely a matter of romantic love or individual choice, especially among the more prominent families, where alliances and land were paramount. For Theodolina, it was more likely an arrangement made by her father or guardian designed to secure her family's status, expand their landholdings, or forge a necessary peace with a neighboring clan. As the wedding rites approached, Theodolina might have started to feel a creeping unease, not just about the unknown future with a new family, but about the very possessions she held dear. Because, according to the deeply ingrained customs and the evolving legal framework of the Salic Franks, the moment she uttered her vows and stepped into her husband's home, most of what she owned, and certainly all of her future earnings, would effectively become her husband's. This wasn't a matter of him being a mean-spirited person or a bad husband. It was simply the way things were, embedded in the very fabric of Frankish society. The Salic Law, which served as a foundational legal code for the Franks, while perhaps not explicitly outlining every single aspect of marital property in exhaustive detail, certainly reflected the patriarchal structure of the society. When a woman married, she often moved into her husband's household and was seen as passing from the guardianship of her father to that of her husband. With that transfer of guardianship came a transfer of economic control. Consider the morning gift, or Morgengabe, a custom often cited as a form of protection for women. This was a gift of property, often land or movable goods, that a husband would give to his wife on the morning after the wedding night. It was meant to be her personal property, something she could retain even if she was widowed. This sounds like a positive right, doesn't it? A beacon of hope for Theodolina. But it was a gift from her husband, not something she brought into the marriage and retained control over. It was also often a relatively small portion of his wealth, intended to provide for her in old age, not to give her significant economic power during the marriage. Her own dowry, the property her family provided her upon marriage, often became part of the husband's household wealth, managed by him for the benefit of the new family unit, which he, as the patriarch, controlled. Let us think about the practical implications for Theodolina. If she inherited a small patch of land from her mother before marriage, upon her wedding, her husband would gain control over its produce, its management, and the decision-making associated with it. If she later worked with her husband on his lands, tending to the crops or livestock, her labor, and the fruits of that labor, were seen as contributing to the household's overall wealth, which was under her husband's domain. She could not sell a piece of land, enter into a contract, or even make major financial decisions without her husband's consent, or, more often, his direct action. Economic agency, her ability to make independent choices about property and money, was severely curtailed, if not entirely absent. Historians studying the economic life of the early Middle Ages, like those who delve into the Carolingian capitularies or the various Germanic law codes, consistently highlight this aspect. The household, or familia, was the fundamental economic unit, and the male head of the household held the ultimate authority over its resources. This arrangement was not unique to the Franks. It was common across many Germanic societies of the time. The logic was rooted in the prevailing social order. Men were warriors, protectors, and heads of families, responsible for providing for and defending their dependents. Women, while crucial for household management, child rearing, and sometimes even agricultural labor, were generally not seen as independent economic actors once married. Imagine Theodolina, after a few years of marriage, discovers a particularly fertile patch of ground on their estate. She believes it would be perfect for growing a new crop that could fetch a good price at the market. She might discuss this with her husband, share her insights and observations from her years of experience. Her knowledge would be valuable. But ultimately, the decision to invest the resources, to dedicate the land, to trade the produce, rested squarely with him. He was the one who could legally enter into agreements, who could buy and sell, and who controlled the purse strings, such as they were in a largely barter economy. Even if Theodolina had inherited movable wealth, like livestock or tools, these items would also fall under her husband's control. If she wanted to sell a cow to buy a new loom, she would almost certainly need his permission and his involvement in the transaction. This lack of independent economic control was not just a theoretical concept. It had profound daily implications. It meant that a woman's financial security was intrinsically tied to the stability and generosity of her husband. If he was a good manager, if he was kind, she might live comfortably. If he was wasteful or abusive, her financial well-being was entirely at his mercy, with very little legal recourse for her to assert control over what she might have once considered her own. This isn't to say that women had no role in the economy whatsoever. They managed households, supervised servants, processed food, wove textiles, and often participated directly in agricultural labor. In many ways, their work was the backbone of the household economy. Their control over the tangible assets and the fruits of their labor, particularly after marriage, was largely non-existent. The husband was the legal owner, the decision-maker, the one who could represent the family in economic matters. Consider the example of widows, who often found themselves in a slightly different, though still precarious, position. Upon the death of her husband, a widow might regain some measure of economic autonomy, especially concerning her mourning gift and any dower property specifically designated for her use. She might even act as a regent for her young sons, managing the family estate until they came of age. But even then, her control was often temporary, and she was still expected to protect the family's assets for her male heirs. Her status was frequently dependent on her late husband's standing and her sons' futures. A widow, though seemingly more independent, was still bound by the societal expectations of her role in perpetuating the male line. If she remarried, she would once again transfer her economic agency to her new husband. The scarcity of this right for women, the right to control their own property after marriage, created a profound dependency. It meant that a woman's worth and security were often linked to her ability to produce male heirs and to her husband's ability to provide. It reinforced the patriarchal power structure where men held the reins of economic power, and by extension much of the social and political power as well. The lack of this economic independence was not just a legal nuance, it was a fundamental aspect of life for women like Theodolina in 600 AD, shaping their choices, their relationships, and their entire place in the Frankish world. It made any individual ambition or financial security a dream largely unattainable unless mediated and approved by a male guardian. Number 2, the right to represent oneself in legal matters. Imagine again, Theodolina, Our young woman from 600 AD, she's navigating the complexities of early medieval life. What if she found herself in a sticky situation? Maybe a neighbor's pigs wandered onto her family's land and rooted up the freshly planted crops. Maybe a dispute arose over a boundary line or a debt, or even worse. She was accused of a minor transgression, like theft or slander. In our modern world, if you have a legal issue, you can typically represent yourself in court, speak on your own behalf, and present your case. You have legal standing. But in 600 BAT, for a woman like Theodolina, the idea of stepping into a malice, the Frankish local court, and speaking directly to the assembly of free men and the presiding count would have been almost unimaginable. The Salic Law, the bedrock of Frankish legal custom, was a fascinating document. It codified a blend of ancient Germanic traditions and new societal norms, laying out everything from fines for cutting down someone's fence to procedures for settling disputes over inheritance. But while it detailed many aspects of daily life, it also implicitly and sometimes explicitly established a framework where women had limited legal standing. In most legal matters, a woman was required to have a male guardian, often her father, brother, or husband, to represent her. This guardian, known as a mundo burdus or mund, was not just an advisor, he was her legal representative, her voice in the public sphere, and the one who held legal responsibility for her actions. This was not a system designed to oppress women maliciously, though it certainly had that effect from a modern perspective. It stemmed from a deeply ingrained societal view that women, while respected within the domestic sphere, were not considered capable of, or appropriate for, direct engagement in the public, often confrontational world of legal proceedings. The courts were places where disputes could escalate, where oaths were sworn, and where physical challenges were not unheard of. It was a man's world, dominated by free warrior farmers who bore arms and engaged in public life. So if Theodolina's family's crops were destroyed by a neighbor's pigs, she could tell her husband about it, describe the damage, and lament the loss. But it would be her husband, or her father if she was unmarried, who would go to the malice to present the case. He would speak the formal words, swear the necessary oaths, and negotiate any compensation. Theodolina's direct testimony might be heard, but only if her guardian vouched for it. And even then, her presence might be secondary to his role as her legal voice. She was in essence legally silenced, unable to advocate for herself directly. Consider also the weight of an oath in 600 AD. In a society with limited literacy and no formalized police force, oaths were incredibly powerful. Swearing an oath on holy relics or by God was a solemn act believed to invoke divine judgment. False oaths could lead to severe penalties, both spiritual and temporal. For women, the ability to swear a formal oath in a legal setting was often restricted or required the backing of male kin. This further diminished their capacity to act independently in legal proceedings, as direct participation in such oath-swearing was central to resolving disputes. The Salic Law itself contains articles that illustrate this. While it does not always explicitly state women cannot do X, it outlines procedures that implicitly exclude them. For instance, in cases of theft or property disputes, the aggrieved party, often a male, would bring the complaint. The fines and compensations, known as wergild for personal injury or other specific payments, would be paid to the male head of the household, even if a woman was the victim. If a woman was the perpetrator of a crime, her guardian would be held responsible for her actions, and he would often be the one to pay the fine or compensation. Think about a more serious scenario. A woman accused of sorcery or poisoning, which were grave accusations in that superstitious age. Her defense would not primarily rest on her own words or her own ability to present evidence. Instead, her male guardian would step forward to defend her honor, to provide compurgators, oath helpers, to swear to her innocence, or to accept a trial by ordeal on her behalf. Her direct agency in clearing her name was severely limited by the need for male representation. This absence of independent legal standing had deep societal implications. It reinforced the idea that women were perpetual minors, always under the protection and authority of a man. This wasn't just a legal formality, it shaped how women interacted with the wider world. It limited their ability to conduct business independently, to own property in a way that granted them full control, or even to enforce their rights in a marriage where they might be mistreated. If Theodolina was mistreated by her husband, her recourse would often depend on her male family members taking action on her behalf, rather than her being able to initiate a divorce or seek redress directly through the legal system. Divorce, though possible, often carried social stigma and was primarily initiated by the husband or through complex negotiations between families, rather than individual petition from the wife. Legal historians point out that while some Roman legal traditions, which existed alongside Germanic law in Frankish lands, offered women slightly more autonomy, the prevailing Germanic customs, especially as codified in the Salic Law, emphasized male guardianship and the subordination of women's legal personalities. This contrasts sharply with later periods or other legal systems, where women gained more rights to appear in court, own property, and conduct business independently in 600 AD. This was a distant future. The daily reality for Theodolina would be that any legal matter, no matter how small or large, would require the intercession of a man. If she wanted to buy or sell something of significant value, the transaction would need to be formalized by her husband or father. If she wished to make a will, it would usually be done under the supervision and approval of her male guardian, often ensuring that property passed through male lines. Her voice, her legal identity was effectively subsumed within that of her male protector. The scarcity of the right to represent oneself in legal matters meant that women, even those from powerful families, were effectively disenfranchised from the public legal sphere. They were spectators, beneficiaries, or subjects of legal actions, but rarely the primary actors. This legal disability was a powerful tool in maintaining the patriarchal social order, ensuring that control over property, lineage, and public affairs remained firmly in male hands, leaving women in a state of perpetual legal dependency in the Frankish kingdom of 600 AD. Number 3. The right to choose a marriage partner. Imagine you are a young woman in 600 AD, perhaps named Gisela, approaching the age where marriage is expected. You might have dreams, secret hopes, perhaps even a fondness for a certain young man you've seen at the local market or at a village gathering. But in the world of the early Franks, the idea that you, Gisela, would have a primary say in choosing your husband was about as common as finding a dragon guarding a treasure hoard. For women like Gisela, the right to choose a marriage partner was incredibly scarce, almost non-existent, a freedom reserved almost exclusively for men, and even then often tempered by family and societal expectations. Marriage in 600 AD was not primarily about individual happiness or romantic love. It was a strategic alliance. For families, especially those with land, status, or power, a marriage was a carefully calculated move on a grand chessboard. It was a way to cement alliances, to resolve feuds, to expand landholdings, or to secure advantageous trade routes. A daughter was a valuable commodity in this complex game, a pawn to be moved for the benefit of the family unit. The Salic Law, while not directly legislating individual consent in marriage, certainly reflected the prevailing social norms that emphasized parental authority. The power of the pater familias, the male head of the family, was immense. He held authority over his children, especially his daughters, until they were married. This authority extended to deciding who they would marry. A father or guardian would arrange the marriage, often after lengthy negotiations with the prospective groom's family, considering factors such as wealth, social standing, political connections, and the potential for progeny. The girl's feelings, her personal desires, were, by and large, irrelevant to these calculations. Consider the reality for Gisela. Her father might receive an offer from a powerful neighboring lord, perhaps a grizzled warrior, twice Gisela's age, known for his vast lands, but also for his stern demeanor. Or perhaps a young man from a rival clan, marrying him, would finally bring an end to a generations-long dispute. These were the kinds of considerations that weighed heavily on a father's mind. Gisela might be presented with a decision, but it would be framed as a fait accompli, a duty to her family, a necessary sacrifice for their collective good. To refuse would be an act of defiance, an insult to her family, and a challenge to her father's authority, with potentially severe repercussions. Concept of arranged marriage was not just a suggestion, it was the norm. Brides were often given away with a dowry, property, or money brought by the bride's family to the marriage. This dowry was a crucial part of the marriage negotiation, a way to attract a suitable husband and demonstrate the family's wealth and commitment to the alliance. The very nature of the dowry system implies that the marriage was a transaction between families, not an individual choice. Even among the lower social strata where land and alliances might not be as grand, pragmatic considerations still outweighed personal preference. A farmer's daughter might be married to a neighboring farmer's son to combine small land holdings, or to a skilled craftsman to secure necessary services. For the family economic necessity, not romantic inclination, drove these unions. There were, of course, some subtle nuances, while direct consent from the woman was rarely a legal requirement. Some later traditions, influenced by Christian doctrines that began to gain traction in the Frankish kingdom, might have implied a spiritual aspect of consent. However, even these budding influences were often overshadowed by the immense social and legal pressure to obey one's father or guardian. A woman might verbally assent, but under duress, knowing that refusal was not a viable option. Let's think about the rare exceptions. What if Gisela was a powerful widow, perhaps from a royal or noble family, with grown sons? Even then, her remarriage would likely be a subject of intense political maneuvering by her sons or other male relatives, aiming to secure their own positions. Queen like Brunhild, a truly powerful figure in Merovingian history, made strategic marriages for her children, but her own choices in marriage were still dictated by dynastic concerns. For the vast majority of women, the idea of picking their own partner was a fantasy. The lack of choice extended beyond the initial marriage. If a husband died, a widow might be remarried quickly, again for the benefit of the family, to ensure the continuity of the household or to prevent family lands from fragmenting. Her reproductive capacity was valuable, and her marriageability was a resource to be managed by her male kin. The Salic Law, in its provisions regarding marriage, focused on matters like betrothal agreements, the proper transfer of the dowry, and penalties for illicit unions or abductions. It laid out the legal framework for how marriages were conducted and dissolved, but not who had the agency in initiating them. The underlying assumption was that the arrangement was made by the male heads of the families. The very concept of a woman having an independent will in such a monumental decision was alien to the legal and social structure of the time. This scarcity of choice in marriage had profound implications for a woman's life. Her entire future, her social status, her living conditions, her security, even the potential for happiness or sorrow was determined by decisions made by others. She might be married to a kind man or a cruel one, to a rich man or a poor one, to a healthy man or an ailing one, without any power to influence that outcome. Her role was to be dutiful, to produce children, particularly male heirs, and to manage the household. It was a world where individual autonomy, particularly for women, was profoundly limited. The right to choose a marriage partner was not just about personal preference. It was about the fundamental right to self-determination, to shape one's own destiny. And in 600 Frankish society, this right for women like Gisela was barely a flicker in the vast darkness of societal norms and legal restrictions, and almost entirely absent freedom in a world governed by patriarchal authority and strategic alliances. Number 4. The right to hold political power. Imagine being born into a world where your gender alone could slam the door shut on any dream of leadership, of ruling a kingdom, of wielding authority over people and territories. In 600, in the burgeoning Frankish kingdom, this was the stark reality for women. The right to hold political power, to ascend to a throne, to govern a region, or to command an army, was almost entirely beyond their grasp. It was a right so scarce for women that it was practically non-existent, reserved for men, and inextricably linked to the very foundation of Salic Law. Political structure of the Franks in 600 odd was a warrior aristocracy. Kings were not just rulers, they were military leaders, judges, and administrators. Power flowed from strength, from the ability to command loyal followers, to lead armies, and to secure lands through conquest or inheritance. This was a man's world, where physical prowess, military skill, and the ability to inspire loyalty among male warriors were paramount. The Salic Law, while primarily a civil code focused on property and justice, indirectly underpinned this exclusion. Its most famous article, titled Lixte Elotis, explicitly stated that women could not inherit Salic land, the primary form of land tenure in the kingdom. Salic land was seen as the patrimony of the male lineage, passed down from father to son. This seemingly simple rule had monumental political implications. In a society where land was the ultimate source of wealth, power, and authority, denying women the right to inherit it effectively barred them from any significant political role. Think about it. How could you rule a duchy or a kingdom if you couldn't even inherit the land that formed its core? How could you command the loyalty of local nobles if you couldn't grant them land or military service in return? The ability to control land was the key to raising armies, collecting taxes, and exercising justice. Without it, political power was a hollow concept. This is why, in the Frankish kingdom, queens were consorts, mothers, or regents, but not rulers in their own right. A queen, like the famous and often fearsome Fredegund, or the formidable Brunhild, might wield immense influence behind the scenes. They might advise their husbands, intrigue against rivals, manage the royal household, or even act as regents for their young sons. Indeed, figures like Brunhild demonstrated incredible political acumen and ruthlessness, engaging in bloody power struggles that shaped the Merovingian era. But even Brunhild, for all her ambition and strength, never claimed the title of queen, regnant, or ruler in her own name. Her power derived from her position as wife to a king, mother to a king, or grandmother to a king. Her authority was always mediated through a male figure, however young or weak he might be. Imagine young Clofeld, a hopeful royal daughter in 600 AD. She sees her father, the king, issuing decrees, leading his retinue, and dispensing justice. She might have a sharp mind, a keen understanding of strategy, and a powerful will, but the path to the throne was simply not open to her. Her destiny was to be married off to another king or prince, to cement an alliance, and to produce male heirs. Her political role would be to be a mother to future kings, shaping their character and education, and perhaps acting as a regent if her husband died and her sons were too young to rule. Even this regency was seen as a temporary measure, a holding action until the male heir came of age. The very concept of a queen ruling in her own right, independent of a male consort or heir, was fundamentally at odds with Frankish custom and the Salic Law. Kingship was an inheritance, and it was inherited through the male line along with the Salic land that sustained it. This patriarchal succession was deeply embedded, reflecting a society built on male-led warfare, land ownership, and patrilineal descent. Even in cases where a powerful aristocratic family might rise to prominence, the head of that family, the one who accumulated wealth and influence, was always a man. Daughters and sisters might benefit from their family's power, but they would not inherit or exercise it directly. They were meant to be married off to extend the family's reach through new alliances or to serve the interests of the male line. This absolute scarcity of political power for women meant they were effectively excluded from formal governance structures. They could not be counts, dukes, or members of the king's council. They could not lead troops in battle, nor could they preside over the public assemblies where laws were discussed and judgments rendered. Their influence was indirect, exerted through persuasion, networking, and manipulation within the domestic or courtly spheres, not through direct legal or traditional authority. Historians who specialize in early medieval governance emphasize this point. While women sometimes acted as de facto power brokers, especially in times of weakness or minority rule for their male relatives, these were exceptions to the rule, not the norm. Their authority was always precarious, dependent on the loyalty of their male supporters, and constantly challenged by rivals who might question their legitimacy to wield power. When Brunhild, for instance, fought to maintain control, her enemies often attacked her very right to exercise power, arguing that she was overstepping her bounds as a woman. The lack of this right wasn't just about a crown or a title. It permeated every aspect of a woman's public life. It meant she could not participate in the decision-making that shaped her community, her region, or her kingdom. Her voice, if heard at all, was always filtered through a male proxy. It solidified a social order where leadership, war, and the public administration of justice were unequivocally male domains. So, for any aspiring female leader in 600, add whether she dreamt of commanding armies or simply managing a county, the message was clear and unyielding. That path was not for you. Your gender, according to the deeply entrenched customs and legal codes of the Franks, made it impossible. The right to hold political power was the ultimate male prerogative, leaving women in the shadows of the throne, capable of influence perhaps, but never of undisputed command. Number 5. The right to inherit Salic land. Imagine being told that the very ground beneath your feet, the ancestral land your family had cultivated for generations, the source of your lineage's power and prosperity, could never, ever be yours to inherit directly, simply because you were born a girl. This wasn't a cruel joke in 600, and it was the law of the land for the Franks, enshrined in their most famous legal code, the Salic Law. For women, the right to inherit Salic land was the absolute scarcest of all rights, so fundamentally denied that it shaped every other aspect of their lives and defined their very place in society. Let us unravel this ancient legal mystery. The term Salic Law conjures images of royal succession, but its origins are much more mundane and deeply rooted in early Frankish society. The Pactus Legis Salicae, codified around the early 6th century, was a compilation of customary laws, fines, and procedures. It covered everything from theft to murder, but one particular article, Title X, often called the Elotis or concerning allodial land, stands out with monumental significance. It stated quite clearly that of Salic land no portion of inheritance shall come to a woman, but all the land shall devolve to the male sex. This was not just about some royal palace. Salic land, or allodial land, was a foundational concept. It referred to the family's freehold property, the land that was owned outright, not held in feudal tenure from a lord. This was the land that provided sustenance, wealth, and crucially, the power base for a family. In an agrarian society like that of the Franks, in 600, land was everything. It determined status, wealth, and the ability to raise an army or command loyalty. Consider a family, perhaps the family of a local chieftain or a prosperous farmer who owned a significant tract of Salic land. If a father had multiple children, both sons and daughters, and he passed away, his sons would inherit all the Salic land. His daughters, no matter how many there were, no matter how capable, would inherit nothing of this primary inheritance. This wasn't a matter of discretion. It was an absolute, legal principle. Why was this rule so rigidly enforced? Historians have debated this for centuries, but the consensus points to a blend of practical, military, and social reasons. Frankish society was deeply martial. Land was the basis of military service and the ability to support warriors. It was believed that women, generally, could not perform military service or hold the public offices that went with land ownership. To allow land to pass into a woman's hands and potentially out of the family if she married into another clan was seen as weakening the family's military and political strength. The male line was paramount for preserving the family's patrimony and ensuring its continuity as a fighting and political unit. This wasn't just about a rule on paper. It had profound daily consequences for women. Imagine a young woman, perhaps named Bertha, whose family owned a vast estate. She might have grown up running across its fields, knowing every tree and stream. She might have had a deep love for the land, a strong understanding of its management. Yet, if she had a brother, even a younger, less capable one, he would inherit everything. Bertha would be left without a direct claim to her birthright. Her future would depend on what her male relatives deemed appropriate: dowry to facilitate a strategic marriage, or perhaps a portion of movable goods like livestock or household items, but never the cherished Salic land itself. The dowry, often seen as a woman's share of her family's wealth, was indeed given, but it was often a fixed sum or specific movable property, not a share of the ancestral land. Furthermore, this dowry, once she married, would effectively come under the control of her husband. So, even the wealth she did receive was not truly her own to manage independently. The denial of Salic land inheritance was a primary driver for the importance of the dowry system. As it was the substitute for land for women, this rule created a powerful impetus for families to have sons. Continuation of the family name, the preservation of its land, and thus its power depended entirely on male heirs. Daughters were essential for alliances through marriage, but they were not seen as inheritors of the primary family wealth. This legal framework cemented a patriarchal system where men held economic and political power through their direct control of the most valuable resource, land. There were some incredibly rare, almost mythical exceptions or workarounds. If a family had no male heirs whatsoever, and the direct male line was extinct, sometimes a daughter might inherit land, but this was a complex process and often involved the land being placed under strict conditions or passing to the closest male relative. Anyway, it was a deviation from the clear intent of the law. The rule was so ingrained that even when situations arose that seemed to beg for female inheritance, the default was always to seek a male heir, however distant. This concept of Salic law and its denial of land inheritance to women is perhaps the most defining feature of early Frankish society regarding women's rights. It meant that a woman's economic and social standing was always secondary and dependent. She could not build her own fortune from the ground up literally. Her wealth and status were always derived from her father or her husband. This structural economic disempowerment fed into every other scarcity of rights for women. Political power. You can't rule without land and the wealth it generates. Denying land inheritance effectively denied political power. Legal standing. Without direct property to manage or defend, a woman's legal role was diminished. She became a dependent, requiring male representation. Choice in marriage. Without independent means of subsistence, land, a woman's marriage became even more crucial for her economic survival. Her family's ability to use her as an alliance maker through marriage was paramount, diminishing her personal choice, control over property after marriage. Even if she received a dowry of movable goods, the Salic Law set the precedent that the most valuable asset, land, was not hers to control, reinforcing the husband's economic authority over all marital property. So the scarcity of the right to inherit Salic land was not just one right among many. It was the bedrock, the fundamental denial that limited women's agency across all aspects of public and economic life in 600 AD. For Bertha and countless other women of the Frankish kingdom, the vast fertile lands of their ancestors were a perpetual reminder of a right they could never claim, a legacy forever beyond their grasp. It was a silent, unyielding declaration by the law itself. The land belongs to the men, and with it, the power and the future.